Greetings, this is Management 570. This is the lecture on employment law, and we're going to go over a whole range of different laws that affect how we manage employees in an organization. And while I don't expect any of you to be attorneys or to want to be attorneys necessarily, it is really important that you understand these laws, because even if HR is there as a guide to you around these employment law issues, if you don't understand the fundamentals of these laws and how they restrain and constrain what you can and can't do, you're going to run into a lot of problems. And so it's better to be proactive, understand these things up front, and then ultimately down the line you can avoid major dilemmas as things pop up. So we'll go through the laws and we'll talk about any questions you have about them in class. There are three general areas of employment law that we'll be dealing with. The first is equal employment law. The second is labor law, dealing with how to manage unions, how to handle the day-to-day with unions. And then lastly, workplace safety law. In all these areas, these laws are different in their approach, but the bottom line approach for all of them is to help us with managing the employer-employee relationship, whether it's through the union representation or whether it's what we need to do in order to keep our workers safe and have safe procedures, or just the day-to-day operations with them. So in terms of labor laws, there are three major laws that affect the union management relationship. In 1935, the National Labor Relations Act legitimated the existence of unions. They had been around since the mid-1800s, but they didn't have any legal standing. And so in 1935, through the Wagner Act, or the National Labor Relations Act as it's also known, they legitimated the existence of unions. So now unions were a legal entity, they could negotiate, they could bargain, and the NLRA basically set up the guidelines for allowing unions to represent employees, and they had certain rules around when they could, what they could and couldn't do. Taft-Hartley came a few years later, and the Taft-Hartley Act was about adjusting some of the rights that management had versus what unions had. And that was the real issue, is that the NLRA really erred on the side of giving labor an enormous amount of power, and Taft-Hartley recognized that you couldn't handcuff management in doing the things that they needed to do. So the Taft-Hartley Act sort of balanced that power and balanced those rights a little bit more, and really communicated to the public, into organizations, what are the things that are non-negotiable, that management has the right to do and has the right to set guidelines on, and what were really the categories of things that management could do. And Taft-Hartley also was instrumental in ensuring that we had we didn't have union shops or closed shops where you could only join an organization if you were in the union. An open shop basically means you can get the job and then you would be required to join the union later, which is really different than using union membership as your screening tool. Union membership can't be used as a screening tool for a job in a particular company that is unionized. So anybody could join as long as they're willing to join the union once they join later. So you can imagine, even though that seems like a subtle difference, there's a really big difference between saying you have to be a union member before I'll even look at you, versus I'll look at anybody for the job as long as they're willing to join the union later. And so they started to establish some of those boundary conditions. Landrum Griffin started to look at union leadership and discuss with them and set guidelines on how they're supposed to behave, particularly around their fiduciary responsibility with union member dues and things like that. So obviously it had some constraints and some recommendations on how to have better behaviors for union leadership, because like in anything, a union is an organization, and it's prone to its own corrupt and unethical behaviors, just as any other business organization would be as well. As long as it's made up of humans, it always has that risk. So, and more specifically on the issues of workplace safety is the Occupational Safety and Hazard Act, and it really outlines what workers can and can't do, and what employers should be doing regarding issues of safety, making sure that people have, a safe workplace to work in, that the company is looking out for them as much as possible. So OSHA regulations are about the standards of care that one needs to take in terms of keeping the workplace safe. We'll go into a little bit more about workplace safety and risk management in this lecture. We won't be spending much time at all talking about labor law, mostly because the most important thing to really know about labor law is that if there's a union, there are set rules for how you're supposed to behave around that. And for me, and for the purpose of this class, while it's important for you to know that there are certain rules and contracts about how we're supposed to behave, it doesn't get into, I don't want to get into the nitty-gritty of what those expectations are, because every contract is so different in what it expects. So if you're in a unionized environment, it's important that you know what the union contract says you can and can't do, and be aware of the role of shop stewards and the role of the union in having a voice in the way that the organization is managed. But you would hopefully, beyond the rules of the union contract, be managing your employees, in very similar ways in terms of giving them feedback and advising them and coaching them, and how to be better employees. And so, that sort of thing is the same. Just the rules of engagement might be a little different depending on the labor agreement in your organization. So where does the source of these laws and regulations come from when we're talking about employment law and all the challenges that we might face? First of all, what's the purpose of these laws and regulations? Well, the primary goal is that it's about balancing the power between the workers and the employers, right? But it also is about protecting both of those groups for very different reasons. I mean, employees need to be protected from capricious behaviors by employers, and employers need to also be protected to make sure employees are not taking advantage of them and that they're actually doing the job that they're contracted to do. And so if we're thinking at the extremes, like if you only think that employees are going to take advantage of you, if you only think employers are going to take advantage of you, you have a very adversarial relationship. But if we recognize that there may be circumstances where these behaviors will occur, but our goal is really primarily to work together collectively, it's a very different attitude. It's a very different perspective in terms of the day-to-day environment of the organization. So, but by and large, the laws are there. They don't come out of a vacuum. They're there because laws come when there are misdeeds, when there are bad behaviors that occur, and laws are then created in order to protect those who don't feel like they are being protected. So whether it's the employers or the employee, those protections come through the law. And so one of the first sources of that is common law, and that's the basic way that our system works. It's about workplace torts or employment at will, where you can be fired for any reason or no reason at all. There's no limits to very few limits on when employment at will can take place. I mean, if you're in a protected class, and you can say, well, I'm going to fire you because you're black, or there's evidence that you're firing somebody because they're African American or black. Then, obviously there are some limitations on that. You don't fire someone who's on maternity leave, right? Just because they're on maternity leave. You can't do these things, and there are limitations on when you can do that. And we will talk much more about employment at will and firing people later on in the term, but the goal here is, basic common law addresses issues of torts, of harming another, and whether that's a contract violation or whether there's some degree of a harm and a misdeed between individuals. Those employment at will and other workplace torts sort of cover that under common law. Other sources of the laws that organizations need to pay attention to come from the Constitution. For example, the Fifth Amendment says that people have a right to a jury trial and to confront their accusers and to have a counsel, and all of this affects us in the workplace, because if there is a law that's been violated, people have a constitutional right to a jury trial and to have a counsel and to have a fair trial, if you will. The 14th Amendment is talking about due process and equal protection, and due process is not only a legal term, but it's also a term regarding sort of what is ethical or fair. We want to give people due process. People have the right to defend themselves. People have the right to say, zero tolerance policy on this. You're not giving me a reason. You're not giving me an opportunity to explain my issues and my concerns. You're simply firing me without giving me a voice to defend myself. And so due process really makes sure that we're not just, knee-jerk reaction, getting rid of people because we think they may have done something. We need to have evidence that they actually did it. And equal protection basically means everybody is protected under those laws, not certain groups and some groups and not others. And as we get into the employment laws, you'll see how that plays itself out. Even though we think, civil rights law is about protecting women and minority groups, which primarily it does, but it also does protect white males. The goal in any sort of situation, as you'll see as you get into the stuff on diversity and diversity management, our goal is not to give opportunities for women and minorities and ignore white males, nor is it the same thing to give it to white males and not to women and minorities. It's about ensuring that there's opportunities for everybody. So equal protection means we're all protected under the law equally, that there aren't some that are more equal than others. 1984, right? Some pigs are more equal than others. That kind of thing. So our goal really is to make sure that we are protecting everybody's rights, and our employment law has to do that. So the next act is the statutory law, and again, statutory law needs to be in alignment with the jury trials, the Fifth Amendment, the 14th Amendment. Our statutory law needs to follow constitutional law. So things like the Civil Rights Act of 1963, and then it was amended in 1991, Americans with Disabilities Act, which has just celebrated its 30th anniversary, I think, 1991, 25th anniversary actually. These are laws created by Congress through a whole process of developing a bill and then having it pass both houses and the negotiation process that goes into play. Statutory law, as you know, takes a long time to get resolved. And one great example, if you recall, how long it takes a bill to become a law. I mean, just reflect on those Saturday morning cartoons, or for those of you that may be old enough to remember them, where it was Schoolhouse Rock and I'm just a bill, and it talked about a very long, tedious process that it took the bill to become a law. So be aware that these things are slow to move. So laws don't happen overnight, and they certainly, as I said, don't happen in a vacuum. They happen when there's a lot of challenges, and then we realize that we need to make some changes. And while we have federal law, it's really important to recognize that state and local law also get at these same sorts of statutory rights around employment relationships, but they may be stricter than federal law. State and local law has to do the bare minimum, which is what the federal law dictates, but it can go stricter. It can do more if it wants to. So just because you understand your federal laws doesn't mean you're absolved from understanding what your state and local laws are. And a great example of this is around employment non-discrimination for LGBT employees. There's no law at the federal level, but there are plenty of states that have legislation that protects gay, lesbian, bi, and transgender employees. And there are also many municipalities that protect them even when their states don't. Now, if you work in St. Louis, you're protected as someone who's gay or lesbian because the city of St. Louis has those protections. And many other states have those protections as well. Whereas, the state of Illinois universally has that employment protection at the state level. The last area of laws and regulations is around executive orders, and executive orders come from the president, the executive branch. The president can create an order which affects federal employees or anybody doing business with the federal government, and they can make an order that if you want to do business with the government, you have to do these particular behaviors, or you follow these particular policies and regulations. And affirmative action is one of them, and we'll talk a little bit about affirmative action as we get into the material. So as a very quick review, as we said a few slides ago, the law exists to protect the employee and the employer and to balance that relationship and to have a level playing field for all parties so that things are done fairly. And what you might see in your HR department is that sometimes your HR manager is an attorney because so much of the law influences what we do in HR. I mean, people think that a lot of times HR makes these decisions because they feel like setting up these policies and, for no apparent reason, or it feels like there's no apparent reason. But I hope that as you'll recognize as we go through this lecture, that there's an enormous amount of legalese that has to be managed when you're doing HR in an organization. There's lots of constraints and restrictions and ways to think about how do we make, policies and how do these policies affect people. It's all embedded in these legal regulations, and we need to understand this. So your role as the manager is, of course, to not step in those piles of legal garbage. We want to minimize the legal liability for the organization and make sure that we're doing everything above board. It's HR's job to train you on what those laws are, but absent being trained on them, this course is designed to give you that insight so that if you have any questions about these behaviors, you can go to your boss and say, hey, how do I handle this? Or you go to your HR professional and say, here's some concerns, how do I deal with this? And we can go in and do that. So always, if you have any doubt whatsoever about how to handle something legally, don't take it upon yourself to just solve the problem. Go talk to HR, and if HR is in doubt, then they will contact a lawyer, or you should contact a lawyer, one way or the other. But recognize that this is not something to ignore or to shrug off. The law is very restrictive in how we handle things, and you'll see this as we talk about employment discrimination and interviews and selection, and the law pops up in all aspects of how we handle day-to-day operations of employees. There are 4 major issues that you need to remember around the law. Number 1 is that laws are not written with an enormous amount of detail. They're actually written purposefully vague for a reason. And the reason behind that is because our case law, the way that our court systems work, is we create a general law, and the case law allows us to create the boundary conditions of what is appropriate and what's not appropriate. And so our laws tend to be vague because you cannot think of every possible contingency when you're writing that law. I mean, as we'll talk about briefly, in a few moments, the civil rights legislation wasn't originally going to include sex discrimination, and because it got added at such a late date, it was even more vague than one would expect, and creating major challenges for how do we understand what is considered to be sexual harassment. It took a really long time, almost 20 plus years, for us to determine that sexual harassment is a form of sex discrimination, and that's because the law is so vague. It was really open to all sorts of interpretations. The second thing is that laws, as I said, don't come out of the vacuum. They are written to correct past wrongs. And so if there's a problem and something as bad has occurred, that's when the law comes about. So the bottom line is the laws are written not for the fun of it, but because something seems to have gone wrong, and we need to create the law in order to protect people. Lastly, the interpretation of the laws will change all the time. That's how our case law works. And sometimes the interpretations will drift away from the intention of Congress, and we'll talk a little bit about that as well in a few moments. But the Congress many times comes back when it does amendments and it says, no, there seems to be some misunderstanding in the way the courts have been interpreting this, and we want to make it clear this was our intention in writing this law. And I'll give you some examples of that as we get into it. So recognize that the law is a living, breathing entity, that it changes, and its interpretations of it changes over time, and it's really up to the court system and to Congress to make sure that the integrity of the law and what its intention is stays fairly concrete. Lastly, when we talk about the relationship between the law and ethics or moral outrage, the law is always going to lag behind ethics. It takes a long time for the law to catch up to people's ethical thinking. So that's a lot of times why we have laws that are just make no sense on the books, because ethically speaking, they're not good, but the law is going to take a while to change. And so again, when we think about the laws written to correct past wrongs and the interpretations of the law change over time, laws are going to lag also in how fast they get integrated and put together, because it takes a long time to write a law. Things don't happen overnight. It can take months and sometimes years for laws to pass and to gain some traction to be able to pass and get signed into law. So because of that time frame, because of the way that our court system works, ethical outrage leads the way, and then the law sort of catches up later on. It's important to get some fundamental terminology out of the way, and one of the big ones is this concept of what it means to discriminate. And technically speaking, to discriminate means to differentiate between two or more things. And that's basically what we do. We have to be discriminating when we decide who we're going to hire, whether we're going to hire candidate A, candidate B, or candidate C. We have to differentiate between them to decide who will be the best person for the job. But the term discriminate has been used sort of broadly in the HR lexicon, which when we think of you're discriminating against me, really what we're saying is you are using illegal or inappropriate criteria to make a decision, an employment decision for me or about me. And so what we're really talking about is illegal discrimination. You are illegally discriminating using my sex, my age, my ethnicity, my religion, my orientation, whatever it is, to make a decision about me. So we just want to be really careful so that we differentiate the terminology. Discriminating somebody, discriminating amongst candidates is completely appropriate. It's only when we're using inappropriate or illegal criteria that discrimination based on that criteria is inappropriate. So just be mindful of the terminology as we go forward.